Rivers State Assembly warns Rivers residents not to have dealings with those masquerading as local government caretaker committee chairmen and members. Swing into actions and arrest the imposters, Mr. Speaker urges security agencies. Hello viewers and welcome to InfoGist TV. The Rivers State House of Assembly at its 7th legislative sittings of the second sessions of the 10th Assembly deliberated on a statement by the House Leader, Honorable Major Jack, wherein he drew the attention of the House to the illegal activities of some persons in the state, masquerading as chairmen and members of caretaker committees. These individuals, the leader said, go about imposing and collecting fees, levies and rates from unsuspecting members of the public, in breach of the recent Supreme Court judgment and the provisions of Rivers State Local Government Amendment Law 2023 that prohibits caretaker committees in whatever guise or nomenclature. Debating on the statement by the House Leader, members condemned and berated those they described as imposters and warned all banks, traditional rulers, government at all levels, non-governmental organizations and those doing business in Rivers State not to transact any business with unelected individuals parading as caretaker chairmen, as they are threats to the fragile peace in the state. Commenting on the House Leader's statement, the Speaker, Right Honorable Martins Chike Amehule, averred that more worrisome is the fact that these individuals not known to law go to the banks and withdraw monies meant for the local government council for wanton squandering in the name of non-existing caretaker committees. Speaking further, Right Honorable Amehule urged the police and other security agencies to swing into actions and arrest the imposters to avoid breakdown of law and order in the state. Recall that a federal high court sitting in Abuja has refused to shut down all expenditures of Governor Fubara of Rivers State, pending the hearing and determination of the substantive suit filed by the Martins Amehule-led Rivers State Assembly. Justice Emeka Nwite, in a ruling on the motion ex parte marked FHC/ABJ/CS/984/2024 and moved by Sebastian Honorable SAN, rather ordered the plaintiff to put all the defendants in the suit on notice. Justice Nwite, however, granted another motion ex parte by the plaintiffs to serve the 5th to 10 defendants with the originating processes and other applications in the matter by substead means. Right Honorable Amehule emphasized that the 10th Rivers State House of Assembly, in accordance with the provisions of Section 7 Sub 1 of the 1999 Constitution of the Federal Republic of Nigeria, also altered only democratically elected officials are to manage the local government councils, adding that Section 64 Sub 1 of the Rivers State Local Government Law No. 5 of 2018 further empowers the House to give directive that only democratically elected officials should pilot the affairs of the Council. Reiterating the position of the House, the Speaker stated that the House would not fold its arms and condone the crass disregard to the law of the state and the judgment of the Supreme Court of the land by imposters. The judge said, in his words, the leave is hereby granted to the plaintiffs/applicants to serve the 5th to 10th defendant respondents with the plaintiff's applicants originating and any other processes filed or issued in this suit by substead means, to wit, by publishing same in the nation's newspaper. Justice Nwite adjourned the matter until August 7th for the hearing of the motion on notice. Now, the News Agency of Nigeria reports that the 5th to 10th defendants are Fubara, the Accountant General of Rivers State, the Rivers State Independent Electoral Commission, the Chief Judge of Rivers State, Honorable Justice S.C. Amadi, Chairman of the Rivers State Independent Electoral Commission, Honorable Justice Adolphus Enebeli, retired, and Government of Rivers State respectively. The Rivers State House of Assembly and Right Honorable Martins Amehule, which are the first and second plaintiffs, had through their lead counsel Joseph Daudu SAN filed the suit dated July 14th but filed on July 15th. They had sued the Central Bank of Nigeria, CBN, Zenith Bank PLC, Access Bank PLC, and Accountant General of the Federation as first to fourth defendants, respectively. Also joined in the suit are Fubara, Rivers AG, the Rivers State Independent Electoral Commission, the Rivers CJ, Chairman of the Rivers State Independent Electoral Commission and Rivers Government as the 5th to 10 defendants. Now in the motion on notice brought pursuant to Order 28, Rules 1 and 2 Order 27 Rules 5, Order 28 Rules 1 Sub 2 of the Federal High Court Civil Procedure Rules 2009, and under the inherent jurisdiction of the court, the plaintiffs sought two orders. They sought an order of interlocutory injunction restraining the first, second, third, and fourth defendants from honoring any request, command, order, or mandate, or any banking or other instruments, financial instructions, or other instructions issued by the fifth defendant on his instruction or at his instance or deriving from the fifth defendant's authority, or in any manner fund or revenue of River State or River State government in the custody of the said defendants, or held by the said defendants for the benefit of River State or River State government, or in any way. Now, the NAN reports that the two rulings, which were delivered on July 17th in the judge's chamber, were obtained on Sunday in Abuja by NAN. The Martins Amehule-led Rivers Assembly had, on July 15th, suspended all expenditures of Rivers Governor Similayo Fubara until he represents his budget before the House. The lawmakers gave the governor a 7-day ultimatum to represent his budget, which they said had expired. And now, Rivers House leader Major Jack moved the motion to bring up a resolution alerting the House of the governor's 7-day deadline for presenting the 2024 budget to the House. Following the considerations, the Assembly decided to shut down River State Consolidated Revenue Account, prohibiting any expenditure by Governor Fubara's administration. In the trail of circumstances, the Pro-Wike lawmakers made success through the All Progressive Congress APC when the Federal High Court in Abuja barred the Independent National Electoral Commission (INEC) from releasing its voters' register to the River State government's electoral body for the state's upcoming local government areas election. The court gave the order on Friday in a suit filed by the All Progressive Congress APC, which broadly challenges legitimacy of the local government elections being planned by the River State government led by a People's Democratic Party governor. The River State Independent Electoral Commission has already scheduled 15th October for the local government election, and in his ruling, the judge Peter Lifo also barred the police and the State Security Services (SSS) from providing securities for the state's local government election. An order is hereby made directing the first to fifth defendants to maintain the status quo ante bellum and not to do any act or take any further steps towards the conduct of the local government elections in River State, slated for 5th October 2024, pending the hearing and determination of the motion on notice for interlocutory injunctions the judges ordered. The order specifically restrained INEC from releasing to the River State Independent Electoral Commission and the River State Attorney General a part or the whole of the National Register of Voters for use by the second to third defendants, which are the River State Independent Electoral Commission and the Attorney General of the state. In addition, it restrained the fourth and fifth defendants, which are the police and the SSS, from participating in or providing security protections for the scheduled local government election. The order issued by the court at the instance of the All Progressive Congress adds to the lingering political crisis that has engulfed the South-South states since the coming on board of the administration of Governor Similayo Fubara, who belongs to the PDP. In giving the ruling, the judge directed the APC to file within 24 hours a fresh undertaking indemnifying the River State Independent Electoral Commission, the INEC, and other defendants in case the court later discovers that it was misled to issue the orders. He also granted an order to serve the suit on the defendants through a substantive means by publishing all the filings in the Punch and the Nation's newspaper within 4 days as from Friday. The judge then adjourned for further hearing to 2nd August, implying that the orders would be in force until then. Currently, the defendants will be able to respond to the suit after it served on them. The APC, the main opposition party in River State, has filed an ex parte application as of July 18 to seek an urgent restraining order against the defendants before the hearing of its substantive suit. The party filed a main suit on 15th of July to stop INEC from releasing the register of voters in River State to the River State Independent Electoral Commission for the conduct of the 15th October local government elections. It sued INEC, River State Independent Electoral Commission, the Attorney General of River State, the Inspector General of Police, IGP, and the SSS, arguing that the River State Independent Electoral Commission failed to fulfill legal requirements to conduct the local government elections. The party said that while the River State Independent Electoral Commission is legally bound to use the voter register compiled and kept by INEC for conducting local government elections in River State, it failed to give a 360-day notice to INEC before the election date. Now, the APC's chairperson in River State, Tony Okocha, who swore to the affidavit filed in support to the suit, contending that the Rivers State Independent Electoral Commission belatedly notified stakeholders about the plan to organize the election on the 1st of July. Mr. Okocha said the Rivers State Independent Electoral Commission's elections notice came after the expiration of the tenure of the last holders of the office of chairpersons and councillors of the 23 local government areas in the state as of 17th of June. Therefore, he argued that the election notice issued by the Rivers State Independent Electoral Commission is unlawful, null and void for non-compliance with the mandatory requirements of the law.